Hello, good morning, everyone. And my sincere apologies for the technical issues that I understand you've experienced. Welcome, good morning, welcome to Legal Wellness. My name is Nick Braganza. I'm a partner at the Dubai office of Holman Fenwick Willen, an international law firm. It's a pleasure to be here today to present our employment law update and presentation to you. This is actually the third time that I'll be presenting in partnership with Willis, and I'm very happy to be here again. It's a pleasure for me to be accompanied this time by two of my colleagues. We have Misbah Nizami. Misbah is based in our Dubai office and specializes in employment law. We've also got Lydia Kamiyad. Lydia is based in our London office, but she has extensive experience dealing with legal issues in the ADGM, the Abu Dhabi Global Markets, which she'll be talking about today. HFW is an international law firm. There are some introductory slides which you can read at your leisure, perhaps after the presentation. We've got quite a packed agenda today to get through. We'll be starting off talking about the legal landscape in the UAE. Many of you who've been here will be aware that there are three employment regimes within the United Arab Emirates. We have onshore, so outside the financial free zones, which apply federal law, but we also have the DIFC, the Dubai International Financial Centre, and the ADGM, the Abu Dhabi Global Markets, and both the DIFC and the ADGM have separate employment legislation, which we'll be talking a bit about today. We will talk about recent updates to the law, primarily focused on onshore law amendments, but also the new ADGM employment law, which has only just been issued. We'll turn to employee misconduct investigations. I'll give a brief litigation update. So I'm looking at some key cases that we've seen in the DIFC and ADGM courts, which is primarily where I'm practicing. And we will close our session with a spotlight on harassment and anti-bullying, which are obviously increasingly relevant and important for employers to consider in this region. So just briefly to touch on the legal landscape, you'll be aware that we've got three regimes. Onshore, there is the Federal Decree Law number 33 of 2021, which has recently been amended. That superseded the 1980 labour law. In the DIFC, we have the employment law passed in 2019. And as I just mentioned, in the ADGM, we've had a new law passed in 2024, the ADGM Employment Regulations 2024. In terms of what they cover, there are lots of similarities between these laws and between these regimes, and I think that they are seeking to protect employee rights and ensure that employers respect those rights and comply with them. There are notable differences, though, which are important. First one to consider perhaps is the end of service gratuity. Within the onshore regime and the ADGM, there is end of service gratuity, which is a lump sum payment paid to all employees at the end of their employment. Within the DIFC, there is a different regime with the DIFC Employee Workplace Scheme, which works more like a pension plan, where employers and employees can pay into that plan, and that can be carried over to new employers as an employee moves on. That's a key difference between them. There are fixed term contracts generally onshore, where we have no such limitation within the DIFC and ADGM, as we'll be hearing about later. But there are broad similarities in terms of leave, sick leave, parental leave. There are slight differences in the number of days that are applicable and are legally required under each of those different laws. However, they all exist. Parental leave is enshrined under all three laws. Discrimination is now recognized under all three laws, and that as an issue that people can't be discriminated on the basis of their race or nationality is very clear under the three laws. So there are broad similarities, there are a number of differences, but I think it's important. Let's talk about the recent developments, and I'll turn now to Misbah.
Thank you, Nick. As he just mentioned, we will now be looking at recent developments to the legal landscape, and I will begin by discussing recent developments to the onshore regime. So firstly, the UAE labour law, which is Federal Law number 33 of 2021, was amended by Federal Law number 9 of 2024, and these changes have been effective since 31st August 2024. Some of the key amendments to the labour law include the minimum fine for employer violations increasing from 50,000 dirhams to 100,000 dirhams, and the maximum fine increasing from 200,000 dirhams to 1 million dirhams, which is obviously quite a significant increase. The limitation period for an employer or employee to bring an employment claim has now increased from 1 year to 2 years. So both parties now have 2 years from the date of employment termination to file a labour claim. The decisions of the Ministry of Human Resources and Emiratisation can now be enforced in the same manner as court orders, and this is because the Ministry's decisions now carry the power of a writ of execution. However, please note that this enforceability does only apply to cases with a value of less than 50,000 dirhams. The Ministry can now also instruct employers to continue paying an employee its wages for up to 2 months during a dispute process if the employee's wages have been suspended. And lastly, where there is a disagreement with a decision that has been issued by the Ministry, the case can now be brought before the Court of First Instance rather than the Court of Appeal, as was previously the case. On Emiratisation, there have been no updates to this initiative from last year, aside from the fine increasing, which means that all private companies with 50 or more employees are still required to increase their Emiratisation rates by 2% annually, and they must aim to reach a target of 10% by 2026. There is a 9,000 dirham monthly fine for non-compliant companies for each UAE national who is not employed, and this fine is actually set to increase to 10,000 dirhams per month next year in 2026. On the involuntary loss of employment insurance, all employees working in the federal and private sectors are required to subscribe themselves to this insurance scheme, and it's effectively a way to support employees who are made redundant by providing them with cash benefits. Although the employer is not required to make any contributions on behalf of the employee and the cost of insurance is borne entirely by the employer is required to inform the employee about this scheme. And companies should also be aware, and we have actually seen this in practice, is that if an employee does not subscribe themselves to this insurance scheme, then the employee's labour card will either not be issued in the first place or it will not be renewed upon expiry. And if the labour cards for employees have expired, this means that companies are at a risk of being fined by the Ministry. I will now pass on to Lydia, who will talk about recent developments in the ADGM.
Thank you, Misbah, and good morning, everybody. So I'm going to talk about two key changes in the ADGM in relation to employment law. The first one is in relation to the whistleblower protection regulations, which came into force last year, because there is a key requirement on ADGM entities that comes into force on the 31st of May this year under those regulations. So by the 31st of May, employers are required to have in place written policies and procedures to deal with whistleblowing complaints and to protect whistleblowers. Failing to do so risks fines and other non-monetary penalties. A whistleblower is an employee who makes a disclosure of information that relates to knowledge or a reasonable suspicion that an ADGM entity or one of its officers or employees has contravened a legal requirement. The regulations protect whistleblowers from being dismissed or subjected to detrimental, i.e. unfavourable treatment for blowing the whistle. So these regulations are really important to consider and to ensure that all your policies are in place and employees know how to raise whistleblowing complaints, and you have a system in place for dealing with these. And that applies to all entities regardless of size or number of employees. Separately, the ADGM has also introduced significant updates to its employment regulations, which came into force on the 1st of April this year, and therefore the ADGM employment regulations are now known as the Employment Regulations 2024. The following are just some of the important changes which all ADGM employers should be aware of. Some of these are up on the slide, so I will just touch on some of these key changes. The definition of employee is now less restrictive, and this enables employers to hire full-time remote employees based outside of the ADGM. And importantly, the ADGM employment regulations will still apply to their employment. The new regulations also clarify the definition of part-time employment and the rights of part-time employees, including in respect of leave and benefits, which can be prorated in relation to the hours that an employee actually works. There's changes in respect of discrimination and harassment. So the new regulations confirm that employers can be vicariously liable for acts of their employees in the course of their employment, particularly in relation to discrimination and harassment. However, the regulations also make clear that a defence is available for employers if it can show that it took reasonable steps to prevent harassment, discrimination, or victimisation, which I'll touch on in a moment, from occurring. Again, really important that ADGM entities have in place policies and procedures for dealing with discrimination and harassment. So I mentioned victimisation. This is a new concept which has been introduced. So victimisation, which is now prohibited, is when an employee is treated detrimentally because they've made a complaint about discrimination, because they've brought legal proceedings about discrimination, or if they've given evidence in relation to discrimination. So, for example, if an employee acted as a witness or made a complaint internally about discrimination and were then denied a promotion, denied a bonus, something like that, that would be victimisation and is prohibited. Also in the realm of discrimination, the new regulations introduce pregnancy and maternity as a new protected characteristic. This means an employee cannot be treated less favourably because of their pregnancy or maternity leave. And then some other changes. Overtime provisions have been removed from the regulations. There used to be specific requirements as to how overtime pay should be calculated, but this is going to be left to employers and employees to agree in the employment contract. It's now made clear that an employer can terminate employment for cause for employees who are absent without authorisation. This next one in relation to payments in lieu of notice is one I think may trip some employers up. So the new regulations now prohibit an employer from unilaterally making a payment in lieu of notice to terminate employment. This can now only be done with the employee's written consent at the time that the employer wants to terminate employment. So an employer will no longer be able to rely on a payment in lieu of notice clause in an employment contract. So if you've got those clauses in your employment contract, well worth taking a look and making sure your managers, HR, are aware that you'll no longer be able to rely on this unless you then seek the employee's consent at the time. The final change that I'm going to draw to your attention is that End of service gratuity payments are now payable even if the employee is terminated for cause, i.e. for gross misconduct. And finally, employers have a right to request a certificate of experience in relation to their employment in the ADGM. So moving on, I'm now going to talk about investigations. And investigations will be relevant if you've got an issue of employee misconduct, or if an employee makes a whistleblowing complaint. So to say at the outset, there may be legislation in each of the employment regimes that Nick touched on that prescribes the steps an employer must take. So it's important to check the relevant local law at the time, and the following is just general guidance in how to approach an investigation reasonably, fairly, ensuring that everything goes to plan and avoids the risk of a claim at the end of it. So it's worth saying that minor acts of employee misconduct or performance issues can and should be dealt with informally by a line manager without the need for an extensive investigation. However, if an employee is given an informal warning, this should be disregarded if there is a future disciplinary procedure. A formal investigation into alleged misconduct will be necessary for more serious acts of misconduct such as dishonesty, bullying and harassment or violence, or like I say, if someone's made a whistleblow, a protective disclosure in relation to alleged wrongdoing by the company or another employee. In cases concerning very serious or a large number of allegations, it's wise to form a team involving HR, senior management and external counsel, and potentially even PR if there's potentially reputational risk from allegations being leaked to the media to deal with the investigation. Companies should follow any relevant policy and procedure it has in place, such as a disciplinary or whistleblowing procedure. And normally what you would do is appoint a senior manager as the investigator, and their role will be to establish the facts by gathering evidence and speaking with witnesses. However, it's not for the investigator to make a decision on the culpability of the employee, and that will come later. During an investigation, it is possible to suspend an employee from work on pay while the investigation is ongoing, but this should not be for too long and only if necessary to conduct the investigation. For example, if there's a concern that the employee may interfere with witnesses, or if they've been alleged to have committed bullying and harassment, and therefore there's a risk to other employees by them remaining in the business while the investigation is ongoing. If at the conclusion of the investigation it's likely that misconduct has occurred, the employee should be invited to a disciplinary hearing, which should be chaired by a manager who is not involved in the investigation. The employee should be given an opportunity to respond to the allegations before a decision is reached. In a whistleblowing investigation, as well as any possible disciplinary action against wrongdoers, the company should, if possible, report the findings and any remedial action to the whistleblower in order to demonstrate that the disclosure has been thoroughly investigated. This may not always be possible if it relates to confidential business information, but where it is possible, it should be done so that employees understand that protected disclosures will be investigated and dealt with accordingly.
I think, thanks, Lydia. I think time and time again, I'm advising employers on misconduct in investigations. The key problem that they often face is they don't talk to the employees. So they tell an employee to leave. They may be conducting an investigation, they may not. They may not inform their employee what's going on. You must tell your employees if they're suspended. You must tell them that they will have an opportunity and give them that opportunity to respond to the allegations. Don't proceed on to termination, even if that's, there is, strong evidence against it. This is where employers get into problems, where they don't follow a process and they just terminate without any process, any disciplinary process. And the courts will penalize employers if they don't follow some kind of process. So I think what Lydia has said is very helpful. And I think, you need to be very mindful of that. But now we're going to turn on to litigation. So this is where I'm doing, this is where I'm doing a lot of my work in the courts of the DIFC and the ADGM. We're seeing increasing numbers of cases going through those courts. The DIFC generally hears cases for employment matters in the small claims tribunal, but from time to time we do see them come through into the court of first instance. I've been involved in a number of these cases, starting off with the first one, AES versus GSB. AES was the ex-employer. It brought an action against a group of employees who resigned from AES and moved to GSB. They were financial advisors. This is an interesting one because the court did issue an injunction, so an order stopping those employees from using confidential information in order to solicit new clients or existing clients who they had been with in AES. I was involved in representing the employees actually. Then that followed that AES determined that those individuals had breached that order and brought an action for contempt of court. So we had to defend that action for contempt, and we were successful in defending that contempt application. That case then went to trial in February 2025. So it was a long trial a few weeks ago, but it brings up interesting issues regarding confidential information. Now, the confidential information is paramount to a lot of you as employers who want to ensure that employees do not walk away with your confidential information. But you need to be very clear as to what this confidential information is. When this order was issued and what they asked for was confidential information to be, they can't use confidential information with their new employer. During the course of the contempt hearing, actually, they didn't walk away with client lists or client databases. What they walked away with what was in their head and what was in their LinkedIn profiles, LinkedIn contacts. The court determined that the LinkedIn contacts are not the confidential information of the company unless it's expressly stated in the employment contract that this is confidential information, you can't walk away with it, or that you must delete your contacts that you meet at the end of it, or something of that nature. The court said that, you trying to stop employees taking confidential information, but you don't tell them what is confidential and what is not, it's not good enough. So that was, they were not held in contempt of court. JP Drax and Honore versus Amadio Ferry Ritchie is a very interesting case about a very successful individual who left one employer to go to another. He brought a claim. Actually, the employer brought the initial claim to enforce a notice period, and the DIFC courts did issue an injunction to stop Mr. Ferry Ritchie moving to his new employer, and so he had to keep to his notice period. He counterclaimed and brought an action for an 16 million euro bonus. Actually, the case settled before it reached trial, but it's interesting the numbers, and it's interesting that the court issued an injunction to stop an employee working for a new employer during his notice period. One of the first big discrimination claims was brought by Mahmoud against Standard Chartered Bank. back in 2021, which went to trial last year. This was a very complex discrimination case. The claim failed, actually, and Mr. Mahmood was not awarded damages, but in a long 188-page judgment, the court analysed each and every instance of the alleged discrimination against him. It was found that on the facts, on the evidence, the discrimination had not taken place. There was a lot of implied discrimination, which was not explicit. Perhaps that was one of the reasons why the claims were all dismissed, and Mr. Mahmood was not successful in bringing his claims against Standard Chartered Bank. Another case that I was involved in was Faisal Mulkath versus Expresso Telecom. This was an employee which sat on his employment claims and didn't bring them for a long period. The court dismissed his claims because he didn't bring them within the 6-month period, which is required under DIFC employment law to bring your claims. So employees must bring their claims quickly, or at least on a timely basis, if they want to get the courts to consider them. One ADGM case which has just recently been issued, which is Mathonet versus Modus Operations. This is related to an employment contract which was subject to arbitration, and in that case, the claims were dismissed because there was an arbitration agreement within the employment contract. So they relied on that in determining that. Actually, in terms of the ADGM cases that I'm dealing with, the ADGM is very keen on getting parties to negotiate, to mediate, and so the 2 employment claims that I've had recently in the ADGM haven't made it to trial, haven't made it very far, because the court is very keen to get matters to mediate. We should see that happening increasingly in the DIFC as well, which is now going to start mandating mediation in certain claims, and does do so already in the small claims tribunal. So just moving on to our spotlight issue, harassment and bullying, and I will turn back to Misbah. Thank you.
Thank you, Nick. As an overview, we will discuss the relevant legislation in the UAE, and we'll look at the topics listed on this slide. Can I get the next slide, please? So what is harassment? There is a comprehensive definition of harassment on the screen, but to paraphrase, it is any unwelcome physical, verbal, or non-verbal actions that violate a person's dignity, and this includes creating an intimidating, hostile, degrading, humiliating, or offensive environment. It also encompasses situations where an individual is treated less favorably due to their past submission to or rejection of such behavior. And it's important to note here that even a single incident on its own can constitute harassment. Next slide, please.
Sorry.
The UAE has several pieces of legislation that address harassment and discrimination. Firstly, the labour law forbids discrimination on the basis of race, colour, gender, religion, national and social origin, or disability. And the only exception to this is in relation to Emiratisation policies, which are designed to enhance the participation of UAE nationals in the local labour market. Sexual, physical, verbal, or psychological harassment by the employer, manager, or any other colleague/employee is also prohibited. The law also mandates that female employees must receive the same compensation as male employees for performing the same work. And lastly, pregnant employees and employees on maternity leave are protected against termination and the threat of termination. The law on the support of employment of people of determination places an obligation on the employer to protect the rights of people of determination, and this includes making sure that they do not face discrimination during their employment. Employers are also required to provide such employees with reasonable accommodation arrangements in the working environment. So discrimination in the workplace can result in criminal penalties, in addition to the civil penalties that we just discussed on the previous slide. So the law on combating discrimination, hatred, and extremism makes it a criminal offence to commit any act of discrimination of any form, by any means of expression, or by any other means. And discrimination is defined as any distinction, limitation, exception, or preference amongst individuals or groups on the basis of religion, belief, right, community, sect, race, colour, ethnic origin, gender, or race. It's important to take note here that religion is only restricted to the divine religions of Islam, Christianity, and Judaism. Violations of this law can result in severe penalties, which include hefty fines and even imprisonment. There is also potential liability involved here for a representative, manager, or agent of the company if any of the employees commit an offence under this law, and if it is proved that the representative, manager, or agent was aware of the offence. The UAE Penal Code has various offences, such as assaulting a woman's modesty by words, actions, electronic means, or any other means, sexual harassment, defamation, etc. And again, violations of the Penal Code can result in severe penalties, which include significant fines and imprisonment. It's important to make the distinction between discrimination and feedback that may be given to you by a manager or supervisor. For example, if your colleagues were to make comments or take actions against you on the basis of your race, colour, ancestry, origin, social background, religion, marital status, physical or mental disability, or gender, then this would constitute harassment. On the other hand, even if this would make you uncomfortable, if your manager or supervisor were to question you about missed deadlines or the fact that you are frequently late to work, this would not be considered harassment. This slide lists examples of the types of actions that could be considered harassment. I will not go through them all, but you will see that all of these examples fall under the definition of harassment that I had earlier mentioned. I will give you a few seconds to read through those before moving on to the next slide. As a summary, we have listed the typical types of harassment and discrimination, and you will see that this includes racial, pregnancy, sexual, disability, as well as religion. I will now hand over to Lydia, who will address the topic of bullying.
Thank you, Misbah. So I'm going to round off our spotlight session by briefly covering bullying, which is distinct from harassment and discrimination, because notably it does not have to relate to a protected characteristic that Misbah was discussing, so race, nationality, religion, sex. So that is a notable difference. UAE labour law specifically prohibits bullying or any verbal, physical or psychological violence committed against a worker, whereas the ADGM, for example, doesn't contain a specific definition of bullying. However, bullying at work may amount to a breach of the implied duty of trust and confidence that exists in an employment contract. So there's a general definition of bullying on the slide, and you'll see it focuses on offensive, intimidating or insulting behaviour involving the misuse of power or strength to coerce through fear or intimidation that may leave a person feeling vulnerable, upset, humiliated, threatened or undermined. If I could have the next slide, please. So we've got some examples of bullying here. Spreading malicious rumours, of course, violence, threats of violence, overbearing management and unfair criticism, But as Misbah mentioned as well, in relation to harassment, legitimate, reasonable and constructive criticism of a worker's performance or behaviour, or reasonable instructions given to a worker in the course of their employment will not amount to bullying. You can see on the slide there that bullying can of course happen face-to-face in the workplace, but maybe via electronic communication, on social media, and outside of the workplace. So similarly to talking about misconduct investigations, whistleblowing, all of these difficult issues, really important that employers have in place policies and procedures so everyone knows how these issues will be addressed when they occur, so employees know how they can raise complaints and have the confidence that they'll be dealt with by their employer. So every employer should have a clear policy in place in relation to violence, bullying and harassment in the workplace, which aims to prevent such actions occurring. The policy should state that the company will not tolerate any type of workplace violence, harassment and bullying. It should encourage employees to report any concerns to their immediate supervisor, management or to HR, and state that the company will investigate all reports and that any findings of bullying, harassment or violence will be dealt with and may lead to disciplinary action against the perpetrator. It should be really clear that the company will not tolerate any form of retaliation, intimidation or victimization against a person that makes a complaint in good faith or participates in an investigation, for example, as a witness. This is really important so that employees don't fear raising concerns because they feel like they'll be mistreated if they do so. So it's important that we make really clear that won't be the case, and as well that any witnesses will be protected and not subjected to unfavourable treatment for raising these important and serious issues. So on the next slide, I just touch on reporting and investigating instances of bullying and harassment in the workplace. Much of this goes hand in hand with what I was saying about misconduct investigations. Really important that employees know how that they can report concerns. And then in terms of the process, this should be as already discussed. So disciplinary investigation, investigator appointed. If there's good grounds to proceed to a disciplinary hearing, then there needs to be a separate manager to chair that hearing. And the perpetrator needs to be given an opportunity, or the alleged perpetrator needs to be given an opportunity to respond to any complaints raised. At all stages of the process, anyone dealing with the complaint should handle the information confidentially and sensitively, given the nature of the subject. Support should be given to the employee who's raised the complaint. And then once the investigation is complete, an employer will have 2 points to address: whether the allegations against the employee will be upheld, and if so, what sanctions should be imposed as a result. Similar to other aspects of this presentation, it's important to ensure the action the employer takes is in compliance with any legislative requirements, depending on which regime you're working under. So important to check that, but as a general guide, if the allegations are upheld, the options usually available to an employer are a first written warning for less serious misconduct allegations, a final written warning, or potentially dismissal on notice, or in cases of serious gross misconduct, summary dismissal without notice. But of course, as we've been saying throughout, really important that the employer acts fairly and reasonably throughout the investigation to avoid any issues at the end. So that I think rounds up the spotlight session. I think I'll pass over back to Nick.
Yeah, thanks, Lydia. Yeah, no, I think it's very important that we consider these issues and that you are seeking legal advice on these issues because they are quite sensitive and difficult to handle. Quite often we get employers approaching us who wish to take serious action, go to court, go to the police with these kind of issues. You need to consider very carefully whether you want to open that that line of strategy. Often when you report things to the police, they become out of your control, and you have no control over where that's going to go. A good process of a disciplinary process will work well and may be all that's necessary, and you can avoid legal action which is unpredictable and can be unanticipated. So good. I think we're done. I think we just wanted to tie together everything on this presentation. Of course, where I started was the 3 different regimes within the UAE, and it's important to consider the interplay between them. We had an issue previously about onshore employees moving into the DIFC and dealing with potential claims. So the employees had brought claims against the employer onshore, but wished to move on into the DIFC to another company. So this employee wasn't able to move. Generally, if you have pending claims, you can get an NOC from the court or from the employer to work for a new employer. That interplay doesn't exist between the onshore and DIFC. So that was something to consider, and we were acting in that case for the new employer, and that new employer was unable to employ the guys that it had recruited because he had the employee had pending claims in the courts onshore. So also good to get advice on that issue. It's a competitive market. It's a competitive employment market within the UAE. Lots of movement, lots of people moving into this region, lots of people moving around between jobs. As employers, it's important that you ensure that you have effective protection through restrictive covenants, whether it's to prevent employees working for your competitors or it's to deal with confidential information, and to have post-termination restricted. They need to be very clearly set out in employment contracts so that employees know what they can and cannot do. Time and time again, restrictive covenants and post-termination obligations are not enforceable because they are too broad or they are not clearly defined. So it's important to consider that. All employee rights and obligations must be expressly set out in their employment contracts. If they're not there, consider whether you need to sign a settlement agreement or a compromise agreement at the end of termination, so it's clear what the departing employee can and cannot do. Harassment and bullying for some time were not seriously considered in honesty by employers in this region. I think from what Lydia and Misbah have told us, they are now very important. They are enshrined in law and must be respected and dealt with adequately. So encourage all of you to look again at your policies and procedures with respect to discrimination and bullying to make sure they are compliant with the law and are fair to your employees. I think that's it. Are there any questions? We probably have about 5 minutes and we can address some of your questions. I know that Shivani may be taking those and let us know.
Thanks a lot, Nick. Yes, we do have a couple of questions, and let's quickly take them. But before that, I would like to apologize for the technical issue that we faced in the beginning. I know, Nick, you have already spoken about it. There are a lot of members who've sent us a message asking if they can receive the recording. Yes, definitely. We will be sharing the recording of the session because a lot of you missed the initial part of the presentation. Okay, let's quickly take the questions. The first one, guys, if an employee has a 2-month notice period but chooses to resign and only render 1 month, agreeing to deduct the remaining month from the final settlement. Is that acceptable? Is it legal? Or can the company disagree and require the employee to serve the full 2 months?
Thanks for that. Yes, in terms of notice periods, there are certain contractual notice periods that may be agreed between an employee and an employer. I'm just seeking my notes to see what the obligations are. The law onshore, if we're talking onshore UAE, it must be not less than 30 days and not more than 90 days. If you wish to agree, if you agree to reduce that, it is open for an employer and employee to agree to a lesser amount, provided it complies within those thresholds. If the employer does not agree, then yes, either they must comply with their notice provisions, which they have signed up to in their employment contract, and they will be paid, and employers must pay for that.
Right. Thanks a lot for answering that, Nick. We are yet to receive more questions. If you guys have any questions, please feel free to ask and put your questions in the Q&A tab.
Sorry, I should have encouraged you all to ask questions earlier, but no issue.
Yeah, at least we could have had questions in the Q&A tab that we would have addressed in the end.
No worries. I think if there are no further questions, Shivani, let's close it, I think. But it's been very helpful. Thank you very much. Do not hesitate to contact me. I'm at HFW. You can Google me, and my contact details will be on the presentation when it's circulated, and I'll be happy to answer those.
Thanks, Nick. Would you mind sharing your contact details in the chat box?
Yes, of course.
While we are doing that, Nick, we got another question. Would you mind taking it?
Sure.
Okay, the person says, can we pay the final settlement dues? Yeah, can we pay the final settlement dues for an employee if he left the country without any notification and now demanding the final settlement?
Well, you can pay them. Of course, an employer should and can pay them. If you choose not to, what's the result? The employee has left the country. If he wants to bring a claim against you, he has to bring it in if we're talking onshore UAE, he'll need to bring a claim within the onshore courts. His ability to do so will be difficult if he's not here. Generally, you need to file in person. He could, of course, appoint someone or give someone power of attorney or give a lawyer power of attorney to bring the claims against you. The law will protect him even though he's not here. But generally, practically speaking, it'll be very hard for him to bring a claim against you if he is not here.
All right. Are we able to take one more question, Nick?
Yeah.
We've got another one. The person would like to know, are employers still able to include non-competition clause in the employment contracts?
Yes, absolutely. But it's important to be, as I mentioned, it's important that the parameters around those non-competition, non-compete clauses are clear and not too broad. We have seen cases where, if you ask an employee to agree not to join any other company in the UAE, that will be too broad. Your competitors need to be tightly defined, but provided they are tightly defined, the courts will respect them. But from experience, non-compete clauses are generally onshore are relatively difficult to enforce. But there is nothing to prevent you putting them in your contracts, in your employment contracts, but ensuring that they're tightly defined and seeking legal advice from people like Misbah to advise you on how those should be drafted.
Thanks a lot, Nick. Okay, let this be the last one. I don't see any other questions coming in after this. Is there a time limit within which an employee can claim his or her end of service benefits? The situation would ideally happen when the employee was not reachable initially, and then after some months or years, employee realizing that he could have some dues from the company.
I'm sure I know the answer to this. I think, there is a time limit. I'll need to come back to you exactly what that time limit is to bring an employment claim onshore. It's not months and years, certainly not, and they will be time barred. As I mentioned in the DIFC, we've had experience where an employee brought claims more than 6 months after they terminated their employment, and all their claims were dismissed. So there will be a time limit for even onshore for employees to bring those claims.